Douglas Kellner, co-chair of the State Board. May 23rd special election where Brian Benjamin was elected to the state senate. We all agree with the canvass as submitted. We need to sign it.
No special pens.
And then we also have the certification of Christine Pellegrino elected to the Assembly.
Yeah.
So there's no other business for the Board of Canvassers, so now we'll turn to the meeting of the Commissioners of the State Board of Elections. The first item on our agenda is approval of the minutes of the meeting of June 1st. We have both regular minutes and executive minutes. All those in favor say aye.
Aye.
Opposed? So the minutes are adopted. We'll proceed with the unit reports. We'll start with the co-executive directors, Robert Grimm and Todd Valentine.
I think our first thing I wanted to raise, I guess, is the as we were going to the summer conference, June 20th. Governor Cuomo had issued an executive order for his New York State Cybersecurity Advisory Board to review and assess cybersecurity threats to the election infrastructure and to make recommendations on how to address those threats within 90 days. Oops, sorry about that. So on that day, Todd and I both heard from Peter Bloniars, who is the executive director of the advisory board. Sorry, and we were going up to the conference, so we did a brief conversation. But when we got back, we met with them, with Peter, and he had laid out, at least from his point of view, what their goals were, at least in developing their report. We had been working with Peter Bloniars since, it's almost a year ago, when the first FBI alert came out, identifying threats to the election process last year. Peter helped to, he's been participating in our weekly phone calls, usually in person or on the phone. So we were familiar with him. We had been working with him also on getting some assistance from the state Homeland Security, the state infrastructure people, the state police, a number of state actors who had experience in reviewing some of these cyber threats, and also coordinating with our partners at the federal level. So as part of the effort that they are doing, they had a tabletop workshop on Monday that we participated in. There were about 50 representatives from the area of elections. It was the State Board of Elections, the New York City Board of Elections, Suffolk County Board, and Schoharie County Board. They tried to look at a mix of large, small, homegrown kind of settings as to what some of the risks were. But they also had representatives of the the National Homeland Security, the FBI, state police, Secret Service, military, National Guard, a host of people who serve in some disaster preparedness or cybersecurity protection. So I thought it was very worthwhile on Monday. And it's all to try and come up with, it's not to look at everything, but what are the risks and what are recommendations that they should put in a report to the governor. A follow-up, so I thought it was very worthwhile on Monday. There's a follow-up meeting of the advisory panel itself next week. Mr. Boloniar's indicated that he wanted the state board participation in that, but they're still developing the parameters of the meeting. So once we learn more, we can best decide how to participate in that. But it's mostly what are the issues that we address, that we think need to be addressed, so that the governor's recommendations on, I think mostly standards and the resources to implement those will probably be big in that list. That effort is a recent effort since the executive order. We had been working before the election and after the election with our own team of people and others to look at the list of items that we had addressed before the election that needed fixing. Some we could do before the election, some were a bigger issue that you couldn't really touch that close to the election. It was post-election. So we continue to work on those, meet on those. We're doing a risk assessment of the county boards of elections, and we had issued a survey to all the counties, and we had full participation with the least amount of follow-up work. So one, we thank the counties for all of their effort leading up to their petition cutoff dates where they get really busy to get that work done. We are analyzing the answers they gave us to the survey. Some of the answers are generating some follow-up questions to make sure that we think they understood the question right to give us the right answer, and then look at some of the issues that may need some follow-up that we can ourselves put on a to-do list. It's too early to come up with conclusions yet, but I think it's safe to say, and we've told the counties that I think on their to-do list when they're preparing their county budgets is at least raise the awareness to their local administrators that we think more will need to be done. And as we get more information, they can plug that in, but at least make them aware of that. In addition to our cybersecurity, the state has appointed a new IT Chief Information Officer, Bob Sampson. We met with him on June 19th. He's been making the rounds of agencies, so he came here. The last time they invited all the agencies to meet when Maggie became the new CIO. He's taken a different approach. Instead of everybody coming to him, he's been going to all the agencies and meeting with them. So I thought that was at least refreshing. We're kind of a hybrid in the way we get support from the state IT because we're not, our staff is here. We're one of only 2 agencies where the staff is not all ITS staff. So it's always getting used to activity. On July 24th, the governor issued an executive order in relation to distribution of voter registration applications. They've had 2 follow-up phone calls, as they describe it, to operationalize the executive order. We're still in the learning phase of what that means. And they have another follow-up, either a meeting or something next week, so we're not 100% sure what, other than more forms would be coming in.
They're already rolling this out, aren't they?
They had issued the order to the agencies. The phone calls are looking, for like a to-do list kind of approach.
What I'm saying though is that forms have been distributed through various agencies already, and with people that haven't been trained pursuant to the NBRA, which we are subject to. I'm criticizing the governor's purpose, because I think it's appropriate on one hand. On the other hand, you really have to do this with the right amount of preparedness beforehand. And that means training the people so that they would act in our stead in various agencies and not just willy-nilly hand stuff out or give wrong information, which is dangerous.
We are not a member of the task force. We are, in the executive order, the State Board of Elections is, in their view, to be consulted. As I said, Todd and I have talked. We've talked on the phone to remind them that they haven't asked us anything yet. So, if they consult us, what is it that they would like us to help? We have a training manual for NVRA. We do that. So certainly, if they needed a starting place, that would be a good place to look at what is the existing training we give people in NVRA to do things appropriately.
That should be made clear to the powers that this would be an appropriate approach. And it's been done before, and certainly can do it again. We'll make ourselves available. We always have. But to just go off without us and then try to rectify mistakes later on, I think would be a huge mistake.
Well, yesterday was the second call, and we did reiterate with them following up the call that they needed to do more work to reach out to us to, how do you want us? I mean, it's hard for us to react when we don't know what they want us to do, but they're still learning what it is, what questions they want to ask.
Yeah, I think
certainly that.
I think it's unfortunate we're not on the task force, frankly. I think that if there's a task force that's in charge of voter registration, it would be appropriate for the State Board of Elections to be on it. Have you asked about whether we can be actually on the task force so we're more intimately involved in what's going on?
It said they'll consult and engage us for the task force, so certainly being a member of the task force, I have no problem with either of those. I can follow up with them with that suggestion. I did suggest that they reach out to the board as a group and meet with us and ask us, at least tell us whatever it is they
I think as Commissioner Peterson points out, we already have a program, an NVRA program, which does, I think its goal is to make sure it's a nonpartisan effort that's going on out there for voter registration purposes, and I think utilizing that would make a lot of sense with these new agencies. And I guess I'm a little concerned if they're already rolling this out and those training programs have not yet been engaged.
Well, on the call yesterday, training is an issue to deal with, but they're also just looking at how many site locations do they have, what kinds of programs did they want to do, how many forms do they think they needed.
Right, but they did say that the OGS already started it at the bands up on the plaza, and Ag and Markets is at the fair and going to the other fairs. So,
No, I
yeah.
don't disagree.
I think that's just what they're talking
No,
about.
I certainly. I mean,
I'm not saying this in an obstructionist way, believe me. What I'm saying, though, is that we have the expertise here.
Yes.
And to frankly be, second banana, so to speak, in this bunch, I don't think is appropriate. There's a lot to be learned from this board, and I think we should have full participation in it. If it's done right, I think it's a tremendous program.
Well, I can't.
So you'll pass that
I
along?
will pass that information along. I think we're all trying to make it work for the distribution of the forms in a nonpartisan
Fair enough. Well,
way.
I think from my
So
perspective,
certainly we can share that.
I just would want to urge, just for me, that the governor look at the task force and include us on there, because it just makes sense. And I would ask you guys to forward that, but I would think, in this forum that we're in today, I would like to put that out there. I don't know how the other two commissioners feel, but I think that's an important principle, that voter registration has always been done on a bipartisan basis in this state, which is an important principle to ensure the integrity of the voting and the registration system. So I think we should make it our effort to try to be included.
I think that at this particular point, the announcement has been made. Some of the agencies have started it. This has so many different aspects to it. There's no harm in giving out forms. The other option is to hold back forms, and you want to. There are many people.
But Commissioner, there is a harm in
But
giving
I
out
think-
forms if you're doing it with misinformation. And our goal when
that
we
is
do
correct. We don't know
when we
that.
do training of
We don't know
sites
that
is to
yet,
make
and
sure
I
that the
know that
workers
he
are
has
giving out the
already
right
asked.
information.
He has already had a discussion, and maybe Todd has been involved in it, I don't know, where he has said, we are available, we wanted to do everything we can to assist you. And that was very recent, that conversation took place. So let's see what happens. But I agree with you wholeheartedly. But I don't think there's anything wrong in the interim of more people handing out registration forms. I've done it myself, and I certainly don't give...
Well, I think it's more than handing out,
Direction
though.
is also to assist.
Yeah,
in
my
filling it.
my reading of the order was that the agency personnel will assist
understand
in
that.
that, which is fine, but again, we want to make sure the people that are assisting are properly informed on how to fill out a voter registration
disagreement
form.
on that.
And our concern is if they're not properly trained, they may be giving out misinformation to the public, and that would be unfortunate.
But
So,
all I'm saying is that this happens every day with candidates and everybody else who gives these forms out. And the responsibility here is to get as many people registered as possible. So if, while we're preparing for the kinds of things that you want done, or that we want done, we hand out more forms, I don't think there's anything wrong with that. If you're giving wrong information, there's something wrong with that.
But I think there's a difference between a private voter registration drive where a private organization engages in that versus the government activity that is engaged in that. And I think that's the distinction we're trying to draw here, is that we have a standard that we apply when we advise state agencies on how to register people, and that's what we need to insert into this program. While the executive order may have laid out some of those steps, what hasn't happened yet, and this is the critical time to get into, is, before, in order to put the cart before the horse, it's fine to have the concept, but what we need to do is say, hey, look, the training it's not hard or difficult to do, but you need to just step back and take it with consistency with the executive order. And that's what I think we're at a point where we need to insert more into that.
Yeah, and I'm not disagreeing with that. I agree wholeheartedly with that. All I'm saying is that if you have some eager people handing them out beforehand, it's not such a big deal. That's all.
All right, so Todd and Bob will follow up to move that, because I think we are all in agreement that training is a positive thing and that the program is a positive thing, and so we want to do what we can to make it as effective as possible. Do you have anything else?
I have one other item, and I just say we're getting close. It's that time of year, session has ended, we don't have a uniform primary for next year, and we have to prepare the calendar to give to Judge Sharp so he can set the federal calendar for next year. So Todd and I talked briefly, we just pulled out what we did 2 years ago, last even year election. There are some changes that happen in a governor's year that don't happen in a presidential, so we also have to combine a little bit from 4 years ago. Mostly, there is a statewide candidate for United States Senate, so we have to bifurcate the state conventions to nominate statewide candidates to meet the federal calendar. So just a little bit, we're working on a draft. We hope for the next meeting to have a more firm recommendation to you, so then by then, if you accept it, we can send.
Well, we're talking about the next meeting at the end of September, so you really should have a final version by then so that we can approve it and you can get it so ordered by the court.
Yeah, we've just looked at the dates and the issues, and we've shared a handwritten version just to make sure, just so you know we're working on it.
Because I think that's about the right time that you want to publicly
I think Judge
set the calendar.
Sharp signed it in October last time, so it's about,
Right.
we're on the same trajectory.
Right.
So that was just point of information.
Good. Anything else, Todd?
Well, and just following up on the cyber issues, one of the things that we want to push for, or we will probably need to push for if we go into the budgets, our own budget season, Bob alluded to, we were alerting the counties that they need to be aware that this is an issue that they're going to have to face going forward, but we also have to look at, from our own budget perspective, whether or not we have sufficient resources to make sure that our own security is in place. And that's something that, one of the outgrowths we hope of this work is that there's a recognition that both the county and the state boards are going to need resources in some fashion in order to meet the standards that we believe should be met. And we think we've identified a good number of the issues, but it didn't necessarily give us the answers for how it all gets done. And trying to get it done, as we explained to the large group we were working with, we need to do this at the same time that we're still trying to run the election. So we can't just stop and focus on this. Everything else has to continue going on. So that's going to be a challenge as we go forward.
Well, that's good, and I know you prepared a special request last year for additional resources, both for cybersecurity and for our hardware infrastructure, and I certainly support doing that again to make it clearly known on the record what our resource needs are, and then it's up to the governor and the legislature to respond. Anything else? All right, then next is the councils, Kim Galvin and Brian Quayle.
Thank you very much. It has been a very busy period with the designating and independent nominating filing periods having fallen between now and the last meeting. And while it is not a busy time for the receipt of filings by the State Board of Elections, it's an incredibly busy time for the county boards of elections because pretty much all of the town and the vast majority of local elections are in odd years. So we have, as a unit, fielded a very large volume of calls from county boards and others with respect to the petitioning process. Also, on the litigation front, there have been some significant developments in a number of the active cases that we have been involved in, and I think in particular to note, we filed jointly, the board, an appellate brief in the Louder case in June, dealing with the applicability of 16-114 to provide a vehicle for voters to bring proceedings with respect to violations of the election law. We entered into a settlement which was essentially between the DMV and the DOJ, but also involved us in our capacity under NVRA on June 20th, which prevented litigation, which is always a good thing, and provided for compliance as well. And the Department of Justice lauded both the DMV and the Board of Elections for our cooperation in moving through that process to ensure that people who register to vote through the DMV have every opportunity to do so that the law provides. We also discontinued the case in Parish v. Kaczynski dealing with the constitutionality of the village nominating petitions, and there would be a fee application from the plaintiffs yet to be resolved in that matter, but otherwise it is concluded. On the compliance side, we provided 138 additional referrals in June to the deficiencies, in June to the Enforcement Council. The current status of deficiencies is 837 unresolved. 277 that we have sent over have become compliant, and a very large number have been reclassified. I'm very pleased to report that we have a tentative grouping of deficiencies to move over to enforcement that represents this current quarter, and as of now there are about 25 on it. The smallest number that we've ever moved over. The number will no doubt go up because a number of committees have just formed and are filing for the first time in local elections for the July filing. But there's a good trajectory in terms of the level of people who are working with us, getting it right when they make filings, which is very good.
Brian, let me ask you, which filing are you referring to there?
With respect to
The
the
deficiencies, the 25 deficiencies?
The deficiencies would have spread potentially across multiple filings.
Which
So-
file? Oh,
Yeah.
so it's not one filing period?
Correct.
You're talking
Right.
multiple filings. Okay.
Right, so it's those deficiencies that have aged out and the process of getting them to comply is ended within the time frame. It doesn't necessarily relate to a particular filing. We can provide that, but I don't, as I said here, know which ones they go to.
Sometimes it takes more time, but as long as they're actively working and answering, we allow them to continue to try to fix their filings. So at a certain point when they just stop, it could be a variety of filings, like you said.
Couple important staff changes recently. Jessica Norgrove has joined us in the supervising investigative audit position. That position was vacated by Marie Woodward when she took the compliance specialist position that was previously held by Cheryl Kauser. So we welcome Jessica on board. She's only been with us for a few weeks at this point and is off to a great start. Let's see. The other thing that I would offer a note on is that, and we have been as a unit grappling with the issue of special federal voters where there are instances where a voter is entitled to a ballot, a special federal ballot under federal law, but they also meet the definition under Article 5 of the election law as being entitled to a state ballot, and dealing with that that process, which we'll have to deal with by next year, of how we can provide them the federal portion of their ballot within the transmittal time frame of 45 days, and also by the mechanism of transmission that are required under federal law. This used to not be an issue prior to the MOVE Act because no one was concerned when the state essentially decided to give certain voters more of a ballot. Their concern was only that special federal voters, whether they fall into any category that the federal law had identified, get a ballot. So when the means of transmittal and the time frames diverged between those two groups, when there happens to be someone who meets the definition of both, we don't have a ready mechanism in the special federal zone, although we absolutely do something very similar in the military zone for military voters to accommodate that. So we have been working on that issue. It's something that really should be resolved by next year. It could theoretically be solved legislatively, but we think there is an administrative option, and we hope to be coming to you soon with a recommendation on that.
And just to note that the urging and the discussions among the unit was prodded by the Department of Justice. It's not like we were just sitting around one day and decided to
No, I understand.
investigate and fix this issue.
They're prodding us over the state ballot?
Well, they're prodding us over the special federal voters that getting their federal ballot within the 45-day time frame. They don't really care about the state portion.
So right now, who gets the federal ballot pursuant to the MOVE Act?
Well,
Military
Military and
Sure.
special federal
and
voters.
and who are these then that we're talking about? These are
there's-
not special, these are overseas, these are people who are temporarily overseas.
Temporarily overseas that continue to maintain a residence in the state of New York.
So they're not a special federal voter, but they're in
By
a similar,
definition.
but they're in a similar situation.
Correct.
As a special federal voter, so
So
they're urging us to
ordinarily-
treat them the same way.
Right, so ordinarily, we would send them the full ballot
Right.
at the deadline,
But later,
but
Right.
32 days out.
right, got it.
So they're saying, well,
We should treat them the same way we treat a military.
essentially, in getting them the federal portion within the 45-day
And
limit.
the hesitancy here is you feel that the state law,
We don't really have a hesitancy.
oh, you don't, okay, so we're inclined to do what the feds are telling us to do, that we should provide them with the same ballot we provide the special federal voter.
Well, from my opinion, we looked at the issue, and some wording was a bit problematic, but we believe administratively we can effectuate the change without the requirement of a legislative change. And the Department of Justice is always happier when we don't need to go to the legislature for change. But I think we can effectively do it through a regulation and administrative remedy here.
it really is about providing people the state ballot. I mean,
Right.
because under the federal definition, there are three categories of individuals who they believe, who the federal law requires, receive a special federal ballot. And the category that is concerning is where someone says that I am a citizen residing outside the United States and I intend to return. So within that subgrouping, you can have someone who, for example, is working in Germany for 2 years and is a bona fide resident of that place, but is also very much still a resident of the property that they maintain in New York. And so back in the day, it didn't create much of an issue. The Board of Elections would see somebody in Category A, and they'd say, hey, just send them the whole ballot, and we're all done. The problem now is that half of the ballot the federal piece has to be transmitted 45 days before, and the electronic transmittal options need to be available for that portion. So the Federal Voting Assistance Program sent a letter to New York and Wisconsin and informed us that we are the only two states that have interpreted Category A to simply mean that you are treated as a regular absentee voter. They want to make sure that with respect to the federal portion of the ballot that those voters are treated as a federal voter. The upshot is that with the administrative change that we would recommend, there would not be any new category of person getting any more ballot than they were getting before, but the federal piece of what they were getting before would go by 45 days and would go.
So they'll
by
get two
electronic
ballots.
transmittal. Just
Right.
like the
Just like the
military.
military.
Just like the military, they'll be
Right.
getting a federal ballot and then a state ballot.
Right.
Yeah, and we,
So it's really incorporating these people into the process
Correct.
the county boards are currently using for
Correct.
these other voters.
and we've researched the issue and provided a memorandum previously that outlines the basis for it.
Can you give us a report on the litigation with respect to New York City voter registration and the settlement negotiations and why it isn't settled yet?
I can offer just a little bit of a report on it because I don't know a ton, but I actually did speak with someone in the Attorney General's office this morning, actually pursuant to your question, Commissioner, and was informed that they believe that it is likely that settlement will be somewhat imminent, and that the process has been amicable and positive. And I believe that from New York City's point of view, we heard something similar as well. So, knock
We
on
know
wood.
why it hasn't settled yet?
I do not know specifically why it hasn't settled yet, other than there are a lot of parties, and so I'm purely conjecture on my part, and that the issues raised are substantial and complicated. But I don't know specifically why it hasn't, but certainly the Attorney General seems to
What are
imply
the
that-
substantial issues?
the issues that were outlined in the Attorney General's letter in terms of the issues that they saw occurring in New York City as a result of what happened after the purge with the voters and their concern about the overall process. So the subject matter is highly operational and very specific. I don't have any other information other than what was in the complaint originally and what was in the Attorney General's letter to intervene.
All right. So then we'll go to election operations. Brendan?
Thank you, Commissioner. This was also a very busy time for our unit as well. We had all the designated petitions. We have 77 petitions that we had, 236 delegates, 211 alternates. We did have a declination, a substitution, 2 general objections, and 2 specifics, which are on the prima facie report that'll come up later. Units also worked to prepare the certification documents from the May special election for the Senate and Assembly District. We had another recent retirement in the for Supreme Court in the first JD that was sent out. We also have 2 de minimis changes that doesn't have to be voted on, but we just have to notify the board. One of them is a scanner for Dominion, and then another one is the audio tactile interface, which are the Bob has those. It's an end-of-life issue.
It doesn't affect the user. There's the older, they look identical. It's the internal components that are end of life.
Just pursuant to the regulations, we have to let the board know about that. Also, we have, for the next meeting, which could be voted on, would be the functional testing that we had on the Dominion Statement of Votes cast record that are in your packets for review. So if there's any questions about that, we can discuss that. We also had a ballot draw for the conservative judicial delegates in the 9th JD 98th Assembly District. And I think that's about it, if there's no other questions.
Thank you. Public information, John Conklin.
Thank you, Commissioner. The Public Information Office has been busy since our last meeting. We we've had many, many calls, as Brian said. It's a local year. There's been lots of questions about petitions and things to do with local petitions. Also, the July filing, the periodic filing is always a topic of major interest for the press, and we had a lot of calls regarding that. Tom and I participated in the monthly Election Commissioners Association calls in June and July. The annual report is completed, and you should each have a copy of that for 2016. Tom and I also participated in all the meetings that were mentioned about the cybersecurity issues. The unit completed 72 foils in June and 103 in July. For the website, we posted the draft language for the third statewide ballot proposal that was passed at the end of the session with regard to the Adirondack Land Bank. We also posted filings for the petitions that were filed for the judicial and delegates and alternates for the 2017 primary election. For NVRA, we visited the Otsego, Cortland, Shenango, Sullivan, Fulton, Schoharie, Hamilton, and Onondaga boards for nice voter reviews since the June 1st meeting. And all those boards were found to be compliant. Tom, do you have anything to add?
The only two things I would add is that obviously we reminded boards about the deadline on August 11th for sending out their ballots for the primary to their military voters. And I've also reached out to the counties about updating their poll site information with us, because at times they consolidate their poll sites for a primary, and so if voters are coming to our site to look up their record and see where they go to vote, we want to make sure that they have up-to-date information. So that's in process. That's it.
Thank you. All right. Information technology, Bill Cross.
Morning, Good afternoon, Commissioners. I start off with projects, particularly Capus Vitus. Our main issue continues to be resources. The project remains in need of two development staff, but I'm happy to report we've identified two individuals, finally, for these contracted positions. Both are scheduled to start later this month. We did, however, lose one state employee, BOE programmer, to another agency, and we've started the process to refill that position. So at least in this case, it's 2 steps ahead, 1 back.
Can I ask you a question? When we lose an employee to another agency, is it a higher job or is it a better pay? What is it?
It could be either. In this case, it was a lateral. They wanted to pursue a different type of development than they were currently working on. In this case, it was lateral, but it could be either. It could be promotional or lateral.
Is it generally trouble to hire IT people when you're competing with private enterprises?
Yes and no. The state has issues in terms of their process for hiring IT. The two legs of it is one is continuous improvement, or basically entry level, that civil service has laid out, and it's relatively low pay, low grade items. There are promotional opportunities once you're in, and there's a mechanism for those promotions, but to bring in new talent at a higher level or a higher skill level or a specialized skill, which like many professions these days, it's become all about specialization. That mechanism is extremely difficult to navigate. You really have to get someone you feel some promise in entry level and mentor him and bring him up through. It's very difficult to bring him in at a specialized level. For that, generally, our only mechanism is to rely on contractors there. And of course, for that, we pay a hefty price for it, sometimes double what we would pay for a state employee. So it is difficult that way. In this case, this particular position is an entry-level position, and so we can go out and we'll have a larger range of candidates to pick from. But we did also advertise for lateral for people in other agencies doing similar work, to give them the opportunity to transfer over to us as well, and sell ourselves a little bit. But yes, that is a problem. For recent progress, we continue to develop use cases for the multiple processes related to candidate management, as well as EFS, and we're making good progress there. We also continue development on the EFS screens, I think most of you have seen. We also continue to investigate some technologies that hopefully enable us to reduce the custom development effort I've talked about before, and pull in the timeframes a bit. We're looking at several items there that would hopefully assist there. We're also planning for stakeholder outreach for both the Treasurer and County Board of Election working groups. It's been some time since they were engaged. We're currently working on schedules and agendas for those. For EFS, we'll be providing a demonstration of the system in its current form, similar to what we provided you, and be soliciting their feedback. For counties, we'll be looking to discuss various data collection processes and how that data will flow between their current systems and ours, and the process and timeframes in which that will occur. Those meetings, we're targeting the end of August for the Treasurer Working Group and the end of September for the County Board Group. For Nysboe, we continue to work extensively with the vendors for the Sure.
On Capus Vitus, what is the current schedule? When do you think that we'll actually have the beta program out?
The full schedule, including testing, rollout, and everything, as I related last time, was still April 19th. We will obviously have pieces available before that, including betas and such. For
April
working
of
groups.
2019.
Or 18?
No,
19?
April 19th.
That's a year and a half from now.
It is a year and a half now, yes. But that's given also current resources, so we're hopeful with bringing on these additional resources and eliminating a lot of the custom development that is currently in the plan, that we can pull that in. So that's what I'm striving for. But that's end-to-end. That includes testing and training and rollout. We will have beta testing and certainly
All right,
more
well,
involvement before that.
I just wanted to know. And I note that that's 4 years beyond the initial date that was promised us.
Understood.
Long before
I'm
you were
trying,
here,
yeah.
right?
But it's certainly a priority for me, so I'm trying.
Okay.
Nysboe, we're continuing to work with the vendor. We've finished up plans for the new infrastructure, networking, servers, etc. And all the acquisitions for any required hardware, software are now in progress for that. We've also started implementation of that for several areas that don't require acquisition, such as locally here, reconfiguration of networks, things along those lines, for particularly for disaster recovery and and communications between our main site and our DR site for redundancy. We're also working on development and in-house application to replace the Move application, and that development is going well and on progress, on track. Security is also a very large component of our activities. One of the benefits of going last is a lot of it's been covered already. Bob covered our activities with NYSTEC and the risk assessment, as well as the Governor's Cybersecurity Review and our participation there. We also continue to work on several of the longer-term aspects of what we identified pre-election, which includes enhanced monitoring of our systems, scanning, and some intrusion detection pieces that we weren't unable to do in the short time frame for election. We're currently investigating some options there and are engaging some vendors and researching information there. Bob also mentioned our meeting with the new state CIO, Bob Sampson. One of the things that was also discussed in that meeting and came out of it is the state is moving now to their permanent data center, still at the same facility, but in a different building. They were looking to us to move as well. However, their time frame put it smack dab in the middle of essentially our business season, election season. We started really see some pressure to move anyways. That meeting was very productive, and him recognizing that and willing to, allowing us the time we needed to do proper planning and address it at least after the beginning of the calendar year. So we've got that commitment from him. Website is pretty much experiencing normal levels of activity for this year. We have seen an uptick of approximately 25% on key pages related to, of course, campaign finance searches and reports for July. That's what I have.
Any questions?
Nope.
All right.
Thank you.
Next is enforcement, Risa Sugarman.
Good afternoon, Commissioners. I thought that I would ask that you, I know you have questions for me, so I figured that I would start with your questions for me instead of starting with my statements. I know that you have questions, so we could start with that. No?
You don't have a report then?
I usually start and then you have questions, so I figured we'd start with the questions. I know that you have some.
The usual contents of a report, Ms. Sugarman, would be to report on the cases that have been referred to you by the compliance unit and what you have done with respect to those cases, how many proceedings have been initiated, and what's pending. Then, next part is with respect to the complaints, to report on the complaints received and the disposition of the complaints received, and particularly the requirement in the statute that you notify the commissioners when complaints have been closed. Third is the receipt of judgments and collections. And I'm sorry if I'm being pedantic, but I understand that with all three of those that you're not particularly interested in reporting to the commissioners, and I think the assumption on the part of the commissioners is that there is nothing to report, and therefore, all right, I've said enough.
Well, I believe that in my annual report that I gave to you the judgments that were collected. I don't have a copy of the report with me, but the judgments that were collected both on the enforcement and on the judgments that had been obtained by the prior unit and had been collected by the division during the last calendar year. So that is contained in the annual report. I do not have the amount that were collected between January and July of 2017. I continued to view the non-filer lists that are submitted or that we at the division obtain from the IT and review those with an eye to determine what, if anything, that I will do with those. I did that for the January periodic. You asked me at the June meeting to meet with Brian and Kim to determine whether there was anything that we could do with that list. We had that meeting. The discussion was, I'm not sure. Thank you. I think that the reason that it was, and perhaps I'm sure that they will, Brian or Kim will correct me if I'm wrong. Brian considers the list accurate and valid. And Kim was willing to discuss it, I think is more what we got out of that meeting.
Well,
Go ahead.
just, you know,
No,
I
go ahead.
think that Brian's point was not necessarily that the list was infallible, but even though there are some things on there that were old or the people were in jail, the vast majority of the list was still valid.
No, I think that he actually said that he thought that the list was a good list.
Why don't you get to the point?
Well, I think that when we sit down and ask for a conversation about the list, when you have that kind of a disagreement, it's hard to go from there. When I look at a list of non-filers and I try to determine how to deal with a list like that, it's very difficult to organize a strategy because, in my opinion, the list is it is filled with committees that should be terminated. It's filled with, and I'll give you an example why I say that. Right before the July periodic was due, I know that the compliance unit sends out a postcard reminding people that the July periodic was due. And that the last time I sent out a blast email to active committees, it created a firestorm because of the determination of who should or who was required to file. So one of the things that I wanted to do at a meeting was to cull the list with compliance to see if we could come up with a list that was agreeable among all of us. And Brian's position was, and I believe is, that pre-filing is, in his words, a quintessentially compliance function. So what I did was I sent the email to candidates for local committees, and we sent it to about 900, let me just make sure. We sent it to 946 emails to candidates who had a committee that they had authorized or were authorized to file and were on a failure to file list and had failed to file the January periodic. And we told them that they were associated with a committee that had failed to file the January periodic, and that their treasurer was so-and-so, and that this targeted email was to notify them that the July periodic was due July 17th, and that in some cases that you as the candidate are unaware that your committee hasn't filed your January periodic, and if you have a question, please notify our investigator. And from that email, we received 262 phone calls or emails. From that email, approximately 200 committees filed their January periodics. And we are working with those approximate 260 committees to get them into compliance. The vast majority of those committees thought that their committees had been closed because there were various explanations. Some of them had run in a primary, had lost the primary, and closed their accounts and just stopped filing. Now, under the law, are they required to file until they terminate? Yes. Some had run and lost in a general election, closed their campaign accounts, and thought that they were done. And this is 2 or 3 years before. Now, when the legislature changed the process and added a hearing officer process, the hearing officer report that we file, and I know that you don't think that we filed enough, Commissioner. The hearing officer reports that we file are approximately 30 pages long. They include the history of the committee, and they include the requirements that we have to prove that it's not a de minimis violation, because one of the things that the hearing officer has to find, if she, because I can say that because the hearing officers that we have left are all women, she has to find, if she's not going to dismiss the matter, is that the violation is not de minimis. So to have a hearing officer complaint report filed, and then a decision made, and then our Supreme Court documents are generally over 80 pages. So it's not the same kind of litigation that was conducted where hundreds of treasurers were named on a petition that was filed before. So to expect, when you get hundreds of calls, and a majority of which the candidates felt that their committees were closed because they ran in a primary 3 years ago, and they thought that after getting a welcome letter that's 6 pages long, and yes, at the end or in the middle, and 3 lines in italics says that you have to file until you terminate. It's been my judgment, and the legislature has said that it's the Chief Enforcement Council's authority and judgment to file the litigation, that I cannot rely on a database that includes those kinds of committees. So I will not rely on pushing a button and obtaining a list that includes those kinds of committees to determine the litigation strategy that I will adopt. And I've told you that over and over again, and to bring this up to me every time for the last 2.5 years, I don't think is something that I find helpful, nor will I
Didn't say a word, I just said front those statistics. Are you finished?
Well, I guess since the only other thing that I would yes, I guess I am, since it really doesn't matter what I seem to say over. The only thing that I would include is that I also, in addition to the emails that were sent out by compliance on the July periodic. I sent also a list to the commissioners about the local filings of the July periodic. And I received emails back from commissioners that also sent to me, except I asked them to help me determine which committees they believed were not active. And an example that I can give you is a county that had 7 committees on that list. And the response that I got from the commissioner was, well, 6 of those committees have been closed for more than 2 years. So even the county commissioners, in spite of the fact that that list was created by the fact that those committees were not terminated.
You really believe the county commissioners know if a committee has been terminated better than us and our staff?
No, well, if you would have let me finish. Even though the list was generated and the committee was not terminated because they're still on the state board list, the committee is not active anymore. The committee is closed and not functioning. So again, is there a committee that is spending money?
What, Ms. Sugarman, the beginning of that meeting, we asked her what we could do to clean up the list, and she said, with her hands raised, how am I supposed to know? So then it devolved into a little bit of this.
I don't know that this is productive.
No, but
We've gone through this over and over.
I agree.
again.
I just want to make
Ms.
one
Sugarman
point.
has no intention
I just wanna
of
make one
prosecuting
point.
these,
Both
and
of-
so you shouldn't waste your
But I
time
have
on
one
it.
point to
Just
make.
do your job.
That everything that she described is quintessentially a compliance function.
Right.
Reaching out before filings, letting people know to file, before the filings due, working with them, that's our job.
Agreed.
And we do
once
it.
you send it to her, her job is
to enforce
file an enforcement proceeding, which she doesn't do.
Correct.
Both sides seem to be doing compliance.
That's right.
Right. All right. As I say, I don't think there's anything productive on this. It's
And I
really up to
agree.
the
I don't know why
legislature
you
to
raise
be
it
consistent.
over and over.
I didn't raise it, you did. You asked what should be in your report, and I
No,
told you
I
the
didn't
3
ask what should
items.
be, Commissioner. I didn't ask what should be in my report.
Your report should include 3 parts each month. It should tell us what you've received from compliance, what you've done with what you received from compliance. Part 2 is what complaints you've received and what you've done to prosecute on those complaints. And Part 3 should be the financial aspects of the judgments collected and fines obtained.
And I respectfully disagree. I don't think that it's my function to report to you as that. My question to you was, you
You
when
said,
I-
do we have any questions? And I
And
said,
the reason that I did that is when I report to you of what I have done over the last period, you ask me what I do on the non-filers. So I figured that I would just start with that. So that's why I did it. Now, I hope that you will not now continue to ask me what I do with the non-filers.
Well, I can't promise I'm not going to ask again. And let me just say that I think this meeting that you're talking about was partially at least prompted by some comments I made at the last
And
meeting.
Commissioner
Which I will-
Peterson and
Okay, fair enough, but I understand, and my hope was that we could find a common ground to identify those committees that we all agree are active and are not filing, which I think is vastly more than the small number of committees you have pursued. So if you can't do it, I guess you can't do it. I can't make you do something, but that was my hope, and if that's not happening, I think
well,
that's
I would like to
unfortunate.
be able to do that, but I can't see the reason for litigating against a committee that was created in 2005 and has been filing a no activity report for 12 years and has tried to terminate but can't because there's a negative balance since 2006.
I think we generally agree that there may be committees that currently exist that aren't filing who maybe shouldn't, maybe they are terminated, they just don't know it. But I still believe there is a large number of committees who are what I think anyone would consider active, who are not filing and we're not pursuing. And that's been my concern and continues to be my concern. And I can't say I won't bring it up again. But I did want to bring up something else while we're talking about this. And you alluded to your annual report that you submitted this year. And I do notice in there, in fact, I have it. You said you didn't have it. I do have a copy of it here. And you do make reference to the $51,000 that you collected in fees. But I've noticed that the number or the amount of information you're providing in that annual report is diminishing. It seems over the last 2 years since you've been here, you've provided more statistics, and this year, for some reason, you chose not to provide almost really any statistics about what's going on in your unit. I think that's unfortunate. I mean, for example, I'll note that in 2014, you made reference to 8 closed cases. 8 closed cases. And as we all know, under the statute, you are obligated to bring closed cases to this board once they're closed, and to notify this board.
Yes.
Since that time, we, according to your statistics, in 15 there were none, and in 16 there's no reference to it at all. So I'm taking from that you have not closed any cases since 2014?
I have not closed any cases, and there are a minimal amount of investigations that are at a status that are ready to be closed. And what I'm struggling with under the statute says that if I find that there is not credible evidence or that I find no violation, notify the complainant, and I notice the board. And in the 2014 report, I provided the board with the letter to the complainant and the report. What I'm struggling with now is the requirements of the statute and the ethical obligations that I am under in terms of the board's document policy. And I'm struggling with how I'm going to notice the board and the board's policy in terms of making those that notice public. So I haven't figured that out yet, and that's what the holdup is.
You've also, I mean, you just stopped providing, for example, information on number of complaints received. So there's no information now in the annual report on how many complaints you actually received last year. There's no, which there was in 14 and 15, there's no report on how many were opened. There's no report on how many were referred. There's no statistics really whatsoever in your annual report anymore regarding activities in your unit, and I'm wondering what happened. You've been reporting that for the last 2 years. Now suddenly you've stopped reporting.
Yeah, it was difficult for me to do the counting. One of the numbers that I counted was how many contacts I got through emails and what I referred to the board. When there was a there was a time during 2016 when my process was to initially when a complainant or a member of the public emailed me and the the contact was more appropriate for the board. What I did was I emailed the member of the public saying that I would refer their email to the to the co-executive directors, and I would forward the email to Todd and Bob. At some point, Bob, because of my disclaimer on the bottom that that this email may contain confidential information, it was his opinion that he could not refer that email to any of his staff because it may be confidential under the policy, the documents policy, or the temporary policy. So what I started to do was to just refer the complainants or the public directly to Todd and Bob. It became difficult for me to count then, and I didn't know whether they then in fact contacted the board. So it became hard for me to count. That's why that number.
So you don't have a number in your own unit of how many complaints you received
I
in
do,
2016?
and I didn't report it. It was difficult for me. I didn't want. I have that number. I can bring it to you next time. I just didn't put it in the report because I wanted to get it out, and it was hard for me to count that. I have a statistic in my what we have amicus of how many cases we open, and I should have included that, and I did not. I can give that to you at the next meeting.
Okay,
All right.
well,
I have a question.
Yes,
You said you sent 900 emails out,
900 and change
200 respondents.
by
Those
email
that
and
you talked about.
260 something.
What happened to the other ones?
I don't know.
Nothing. That's the point, nothing.
Well, I don't know that nothing happened. Maybe they contacted their
I understand.
committees.
You've decided that parking tickets are a waste of resources, and therefore you're not going to enforce the parking laws. And unless somebody's actually doing something that's going to get your unit into the newspapers, you're not interested in bringing the proceeding.
You know,
I
this is the
understand.
second
I
time
get
that
it.
you've said that, Commissioner.
Oh, I've
don't-
said it many
I-
more than 2 times.
But I don't know where you get that. I don't issue press. I don't know why you say that. I don't issue press releases.
The only cases that you pursue wind up in the newspapers.
But
But none of the routine,
Have you seen-
ordinary enforcement work that I believe the statute intended that you should do gets done.
You know, it's interesting that you say that. I think that when the legislature changed the process and added a layer, made it more not difficult, but they made it more.
They thought there'd be 1,000 cases a year.
Did they?
They did, and that's why we went in and
I
had
think
10
that-
full-time hearing officers in the original
Well,
proposal.
they
And-
excuse me. If they had wanted, they could have instituted an automatic penalty system that if you miss the January periodic, you get a $100 fine, a $500 fine. No, they could have, but they didn't.
And they didn't.
Added
They
a
wanted
layer
it to go to the hearing officers.
and then go to the Supreme Court.
To enforce the hearing officer's determination.
But the determination in a hearing officer doesn't require and these are your words, not mine. This is how you described the litigation as the autopilot litigation system. To push a button and draw up an order to show cause in a petition. That's not what the hearing officer process is. A hearing officer process, as I told you, was a 30-page report that takes an enormous amount of work. So it's not 1,000 reports to file for each periodic that's missed. It's a lot of work. And all of those cases that you think can be filed that might be just de minimis, because yes, the candidate who ran in a primary and lost.
Michelle Adolphe.
No, Michelle Adolphe ran and ran and ran and ran, and she pled guilty and was fined.
She got arrested. She didn't go to a hearing officer.
She was sued, what, 10 times by the prior system? Please don't compare Michelle Adolphe. She went through your system of being sued over and over and over again. If anyone should have been through the criminal justice system, it was a Michelle Adolphe.
Are these hearing officer reports public?
Yes.
Yes.
I have a complete collection.
You have a complete collection?
I think if
They
you look
should
at
be
the-
on the,
Thin collection.
I think if you look at we have 14 now. We had one since our last meeting, right? I think we
Yeah.
spent
That's
the wheel.
14 in 3 years.
So we have 2 this year. Certainly you can review them yourself. About
They
20
should
of
be
the
on the-
30
on the
pages
website, but they're
are
not.
repeat, rules and policies, and then probably about 10 pages of analysis, and that may be generalizing it, but some is the standard, here are the rules and
Violate
regs
our policy.
and the rest. But the majority of the 14 are simply failure to file, and the majority of the 14 fail to respond, because they don't have to
All
respond.
defaults.
So, not all of them, there's a certain number.
No, I think there were-
Probably, are they all 14?
well, some of them
Some
settled.
you settled,
but
right,
some
so
of
I
them
assume like
settled.
3 or 4 out of the 14 were, but 10 are,
But that doesn't mean they don't have to be researched.
oh, I just,
Yeah.
you've all done that work, you can look at the report yourself and see,
Okay, well, fine.
what they are.
Okay, any other questions? So we'll turn to new business. The first item on the petition is ruling on the designating petitions. It's a relatively short calendar for this year. Just the 3 items are on our report.
The 99th Assembly District Working Family, we had 2 sets of petitions. One was a single page, one was a full set. So clearly and they weren't tied together, so the single page petition was on its face de minimis in the number of required signatures, but they still have a valid one on file. We're recommending that you rule the one invalid for insufficient. In the 107th Assembly District Judicial Delegate Working Family, they had a specific objection that they needed 35. They only filed 33. They had raised some other issues, but it was invalid on its face of the specific objection. In the 108th Assembly District Working Family Judicial Delegate, they required 31. They only had 18. So we recommend that, and there was no hearings in those 2 because they were just failure to bring in enough at the start.
I'll move to accept the report.
Those in favor say aye.
Aye.
All right, so the report is adopted and those petitions have been ruled invalid. Next is the certification of the statewide ballot proposals. We received the report from the Attorney General. The staff and the commissioners have circulated drafts and suggestions, and we have the final version that I think is a consensus version that the staff has done that has, it's essentially the Attorney General's recommendation with a couple of plain language simplifications.
There was one proofing that I shared with Todd because it came while I was sitting at the table. On page 9, where the highway issue appears in the abstract we missed. I can hand it to you, it's easier, but on page 9, we missed one of the specified highways. It's in the abstract, but we missed it in the form of the question.
Okay.
So we would recommend that.
Yes,
rather than
yes, and that was something the AG had asked us to do.
a number of people had asked
Yeah.
us to, and Todd had raised it in the comments also.
Okay.
Because highways, all county, but certain towns.
All right, and then the other thing is we've numbered the con question as number 1, the pension forfeiture is number 2, and the state forest preserve is number 3. All right, so I move that we adopt that report with that one typo modification.
I'll move
All right, those in favor say aye.
on. Aye.
Opposed? All right, so that is adopted. Next is the resolution on the regulation. Is there a reason the commissioners need to do anything? Okay. All right, so we're on regulations, 6200.7, designation of treasurer removal committee. The resolution was distributed in our packets. Does anybody have any discussion on the resolution? All right, I'll move the adoption. Oh, go ahead, Peter.
I'll move it.
All right. Those in favor say aye.
Aye.
Opposed? All right, that resolution is adopted.
That was 1709?
That was.
Yes.
Correct.
And then the others aren't actually numbered,
Yeah.
John. So the next one is 62.01.2 and 3, relating to the amendment to the Fair Campaign Code.
I'll move that.
All right, is there a second?
I'll second.
All right, those in favor say aye.
Aye.
Opposed? All right, that's adopted. And then the third is the amendment to the regulation governing the procedures for administrative complaint proceedings, 6216.2. And that has been distributed and circulated. Is there a motion to approve that?
So moved.
All right, those in favor say aye. Opposed? All right, then there is the opinion of the commissioners regarding the interpretation of election law section 14-130 with respect to lobbying expenses. So the opinion has been circulated, and I think that the staff did exchange some comments, and that this is a consensus draft, correct? All right, so is there a motion to adopt the opinion? Who's the one who wants to present it or explain it?
14130, right?
Right.
Explain that.
Go ahead, Nick.
Essentially, we got an email from a trade association group, or not an email, a letter, I apologize, asking for a formal opinion of whether it's permissible under election law section 14130 to pay for a retainer of a lobbying fee for the trade associations group, but using their PAX funds to pay for those fees. So we looked at 14130, and as noted in our our letter, there's a two-prong test that we used. First, the first prong is whether the political committee. Well, the first prong is to question whether it's a lawful expense or not, and the second prong essentially is that whether the funds the funds are used to be converted for a personal use, which include, and personal use is defined in section 14130, which includes salary payments or other compensation provided to any person for services where such services are not solely for campaign purposes. So then we analyzed whether lobbying fees are a campaign purpose, and we concluded it is not a campaign purpose. Hence, we concluded that a trade group cannot use its PAC to pay for a lobbying retainer fee.
I would just note, based on your explanation, that the statute says it shall not be, it's not that it can't be a personal use. It's that it can't be a personal use that's unrelated to a political campaign or holding of office. Is that
That's correct.
your understanding as well?
That is
Because
my
you just said it couldn't be a personal use.
That's right.
But it's got to be, it can be a personal use. It just has to be related to one of those activities. Is that correct?
That's my understanding.
That's my understanding as well.
Okay.
All right.
I'll move it.
Is there a second?
Second.
Those in favor say aye.
Aye.
The
Personnel matter, whether we're going to do it in executive session or not.
it's the motion which I am pleased to make publicly to promote Thomas Connolly to the position of Director of Operations. So I'll make that motion. Is there a second?
I have to think this over.
He is from Long Island.
All right. Those in favor say aye.
Aye.
Opposed? Congratulations, Tom.
Congratulations.
We look forward to it. All right, and I think the only thing remaining is a date for our next.
I wanted to bring
I'm sorry.
something up. Two things, I guess. First of all, I just wanted to note that I think we have an agreement on to send out the FOIL request to the Presidential Commission on Voter Integrity, that they would get the public information that's available to everybody. So I'm pleased about that. Secondly, I wanted to bring up an issue that I think needs to be, that I brought up before, but I think needs to be revisited. And that is the process that at least two of our boards are using in this state, which I think are contrary to both state law and our regulations regarding the audit procedures. We have two counties, one is New York City and Columbia County, I'll just name them, that are currently undertaking a process for doing hand counts of ballots outside the parameters of the process that's anticipated by the election law and also 9-11 and also our regulations 6210. They, as I understand it, in New York City, they allow for a full hand recount when an election is within 0.5%. Any office is that close, and Columbia County, I believe, has a process where they have a full hand count under all circumstances. Races. I think that our statute only allows a hand count when the audit procedure mandates one, and the audit is that 3% of the election machines are audited. If there's discrepancies that cannot be explained under those audits, then it is under our regulation ratcheted up. There's a acceleration of the audits, which could ultimately result in a full hand count but may not.
Need the book.
The regulation, I think, allows for an acceleration when you have a discrepancy that cannot be resolved. Then the board is authorized to go ahead and accelerate their hand counts. But I believe that the process that's undertaken by these two, or the policy that's been adopted by these two entities, either the statute, which has the 3% audit procedure, or the regulation, which allows for the acceleration when there's a discrepancy of ballots between the hand count and the vote on the machine, and does not allow just the indiscriminate decision that if a race is close, we're just going to do hand counts whether or not there are discrepancies shown in the 3% audit or not, or again, in the case of one of the counties, we're just going to do a hand count for every election regardless of the closeness of the race, because we'd rather do hand counts. I think that's outside the statutory and regulatory provisions. I think it's something this board should take on. I think uniformity of ballot counting in this state is a very important principle. I think it's something we should protect. I think it's important that the voters know that their ballots are being treated the same across the state of New York. I think this process that's going on right now is contrary to that, because we have these two entities that have decided they will do hand counts in situations where other counties will not. And I think there should be a uniform, and I think the statute anticipates a uniform practice, that the 3% audit is a mandated procedure, and then if the discrepancies occur, you do an acceleration, but only under those circumstances. And I think to allow some of our entities to do it a different way, first of all, treats the voters in their jurisdictions differently, and I think opens up a process where counties then could potentially start enacting local regulations about their ballots, their voting process, that would be contrary to state law and would, I think, undercut the uniformity that I think is very important for the voting process in this state. So it's something I think we should, I believe that they're proceeding under the regulation, which I think they believe gives them this authority, which is 6210-18 of our rules and regulations. I don't believe it does. I believe if you read 6210-18, it clearly sets out that if a board determines that certain discrepancies have occurred, they have the authority to increase the number of hand counts. But from my understanding, these boards are not relying on a discrepancy at all. One of them is just saying we're going to open up all the ballots regardless, and the other one is saying we're going to open it up when the vote is there's a certain difference between the two candidates. And I don't believe either one of those situations is authorized by either the statute or the regulation.
I'm so disappointed to hear you say that, Peter, because I think that the goal should be the accuracy and verifiability and transparency of the election process. And New York City and Columbia County should be commended for going beyond the minimal requirements of our statute and regulations. And I might add that you've omitted Ulster County, where the Ulster County legislature has passed a county statute that requires the county board to do a hand count in close elections involving the Ulster County Board of Elections. The goal here is to have accurate and transparent election process, and these boards have recognized that, well, in New York City and Ulster in particular, that where there are very close contests, that the machines are not designed to accurately count every ballot. And we now have historically in New York 2 election contests where hand counts actually changed the outcome of the election. The first that happened was in Erie County with a close election for town council, where the hand count changed 2 votes, and it actually changed the outcome of the elections. And the second happened in the Bronx several years ago in an assembly primary election where the hand count changed, I believe it was 7 votes out of about 15,000 cast, and the correct winner was actually able to be certified as a consequence. Why does this happen? There are two deficiencies in our voting system that are not recognized by the machine. When the voter marks a mark, an identifying mark on the ballot outside of the voting target area, the machine will not see that mark, even though that mark invalidates the ballot and that ballot should not be counted. Conversely, if a voter misses the actual voting mark, if the voter's mark misses the target but is close to the target and where there is no ambiguity with respect to what the voter's choice was, our own regulations say that is a vote that should be counted, even though the machine didn't see it because the mark was not dark enough in the voting box. Anecdotally, we know that between 1 in 500 and 1 in 3,000, somewhere around that, ballots are not observed by the voting machines. So in close contests, it makes good sense that there be a hand count to determine the correct winner. And I only lament that we don't have a uniform rule statewide that would mandate that escalation for everybody in close contests. And indeed, on a national trend now, we have the state of Colorado, which has just adopted risk-limiting audits. And it'll be very interesting to see how that is implemented on a statewide basis. We've had a number of jurisdictions that have attempted to do risk-limiting audits on an experimental basis in a number of small elections. Colorado will be the first to do it on a statewide basis. But the concept of a risk-limiting audit is you don't need to look at all of the ballots. You only need to look at a small number of ballots to ensure that the machine has accurately counted the ballots, and you escalate the ballots, you escalate the scope of the audit in very close elections, which are relatively rare in our system. And as far as the statute goes, Peter, I just think you're plain out wrong that New York City, Ulster County, and Columbia County have the right to go beyond our statute to make sure that their count is accurate and verifiable.
Okay, well, I guess in response to that, a couple things. One is I think uniformity is important, and I think allowing counties to do it differently around the state sets up the circumstance. For example, I could be, let's say, the state assemblyman, the state senator, a Congress candidate who's running. Columbia County is in my district. They'll open all my ballots. Albany County, for example, will not, even though that's also part of my district. So the voters within my municipality or within my seat, within my district, are being treated differently depending on where they live. I think that on principle is an unfortunate and a bad principle.
Isn't accuracy the goal?
Accuracy is always the goal, and that's clearly what the goal was when the state legislature adopted the 3% audit, which I think was very valid.
But going beyond that only improves the accuracy.
But I think, Commissioner, you're then presupposing that hand counts are more accurate than a machine count, and I do not accept that principle. I think by the mere fact, for example, that we've now adopted a new practice where audits can be conducted by machines, I fully endorse, because I think having the machines audit each other, having one machine audit is a better way to do it than having humans do it, because humans are always susceptible to error. And to suggest to me that a human count is more accurate than a machine count, I think belies experience. I think anyone who sat through the 2000 presidential election and watched those commissioners in Florida sit and do hand counts with those ballots would be appalled to think that that's the way we count ballots in this country, and that's why we've adopted machines. That's why machines have become the way to count ballots, because I think there's been a general consensus. The machine counts are more accurate than human counts, because humans are invariably subject to error. And so to suggest to me that human counts are going to be more accurate than machine counts, to me, is just, experience is not that. So I think expanding the hand counts without any provocation, without any evidence that there's a problem with machine counts, is not a good way to go. But that's not even my overall point, as much as the state legislature set out a process which was adopted for all counties to follow. We've now had a couple, and now you're telling me 3 counties that have decided to go another route. I just think that's unfortunate. I think it's against state law.
More than what's required.
But I think there's a decision
doing more.
More.
It doesn't.
No, not more. Different. That's not fair. More is not the right answer. The answer is they're doing it differently.
No, but they have to do everything. They have to do everything that the statute and regulation requires, and they are doing more.
That's the wrong way to put it. They're doing it differently.
No,
They've decided to substitute human intervention.
What you want to do is prevent these jurisdictions from having a more accurate count in close contests.
That's absolutely the wrong way to put it.
Yeah, but that is what you're doing.
No, I'm
Peter.
not.
That's exactly what you're doing.
No, Commissioner, that's wrong. To say that that's more accurate is to assume that human intervention is more accurate than a machine count.
In the close contests where you have all these lawyers around the room watching every single ballot that's being
Commissioner, the law
I have never heard a single lawyer object that the hand count was inaccurate in the close contests where the hand count was conducted in New York City. And that's because you've got a room full of lawyers and partisans looking at every single ballot.
That's because those counts have been done under the auspices of a court case, where the court took jurisdiction, and this would still be allowed under our statute. This does not prevent full hand counts. This would only mandate that if you want a hand count under those circumstances, go to court, have a judge oversee it, rather than just willy-nilly doing it every time that you have a close election.
You say willy-nilly.
The situation that you're outlining, well, you can dismiss me, Commissioner, but
no, because you're wrong. You're factually wrong.
No, I'm not.
So, for example, in the Pichardo Assembly primary case, which is just one of the examples where the hand count actually changed the outcome, the court case came after the hand count, okay? But nobody argued that the hand count was inaccurate.
I'm just telling you that I think if you want to have that type of thing...
And I don't know that you've actually gone to look at these to actually
watched counties
do
doing
your
hand
due
counts.
diligence.
Well, that's not fair, Commissioner. I've been there when counties have done hand counts, and you know that. And I've seen how they act. So I don't think that's fair at all. But at any rate, I believe this is an issue that should be addressed. I think it's wrong. I think to have counties out there doing it on their own without any basis in law is wrong, and I think it's dangerous for us to open this up like this. What's to say a county couldn't start doing other things that we may not think comport with state law, but they've decided it's a good idea?
They're doing more than what's required by our statute.
That's not correct. They're doing it differently. And more is not the right answer.
Under that, I think it was Ulster County, you said, it was a local race that was decided by 2 votes.
No, well, in Erie County, there had been a court case that went all the way to the appellate division. The appellate division remanded, and the parties just agreed consensually to have the board do a hand count. And so that's how it happened in Erie County.
I believe you said something about the hand count.
Change 2 votes.
Change 2 votes because of the marking on the ballot that
Correct.
the machine didn't pick up?
Correct.
And which race was that? That was in the one you're talking
Well,
about?
In both the Erie County situation
One
and
was
in the
court
Bronx.
supervised, the other one wasn't.
No, it wasn't, neither one of them were court supervised.
I just think it'd be an awful long time.
There was
for
a court
statewide
case
voter.
pending, but the parties agreed that there should be a hand count just to end the litigation. That was in the Erie County case. In the Bronx case, it was just done pursuant to the standing policy of the New York City Board that there is a hand count in close contests. And the city board does this, I don't want to say routinely, because the number of close contests where that's triggered are rare, maybe only one or two a year.
That's why it's interesting
But-
that they use the other counties' totals to get to their 1/2 of 1%.
Who?
New York City. In their guidelines, let's say there's a Nassau, New York City race,
Oh.
they determine their 1/2 of 1% by including Nassau's unofficial numbers.
Yes.
In order to open all their ballots.
Yeah, it makes sense to me, in terms of what the city did. But I think the city number could be reduced, the threshold could be reduced, if they use the sliding scale based on the number of votes in the contest. That the 0.5% threshold, well, actually, they do reduce it for citywide contests, but I'm in favor of adopting a uniform standard on this if we had a standard for close contests. And I think it's a serious mistake that when we know that the machines miss a certain percentage, very small percentage of ballots, that in the closest elections that we don't then go look at the ballots to see whether the
Commissioner,
machine
that can be
counted it.
easily done by going to court and telling a judge, this is a close election. I think there may be some ballots that have been missed. We should open up the ballots and have the court oversee it. That's
As you
perfectly
know,
allowed
in
by
Martin
law.
versus Johnson, the Court of Appeals, in fact, that's what I wanted to do originally, and when we originally adopted these regulations, we thought that was what the standard was going to be. And then in the Martin decision, the Court of Appeals ruled just the opposite. So that now you actually have to find a discrepancy under the court-ordered
Right,
provisions.
because I
in
think the
order to
court was
escalate.
agreeing with me that the state law requires a discrepancy to be shown prior to an escalation of the hand count. I think that Court of Appeals case supports exactly what I'm saying, which is the only time you should escalate is when you have demonstrated there's some sort of discrepancy here that the audit has uncovered. And then you would open up the ballots.
But
the fact that people don't like the state
But-
law doesn't mean it's not the state law.
But you
The
see,
state law
our
is what
audit
it is.
exempts-
If you don't like the state law, what you do is you go to the state legislature and you tell them the state law should provide for this, let's provide. Fine, we can have that discussion. But to say state law doesn't allow for it, but I think it's a good idea so the counties can just do it because I like it, that's not the way we run elections. We run elections pursuant to common practices by state law that are statewide, applied statewide. Commissioner, just because you like it doesn't mean that's what happens. It takes a consensus of people. The state legislature visited this when these machines were purchased. They adopted a 3% audit. Fine, that's what we decided to do. I know you'd rather have a risk limit audit. I'm open to that. If we can convince the state legislature to change it to a risk limiting audit, fine, let's do it. But to say, I like that, so why don't we just allow counties to do risk limiting audits now? Because it's not provided by state law, that's why. Well, if you want to provide it, have the state adopt it, fine. But this idea that a county can just on its own decide, we think this is a better way to do it, well, that's not your choice. It's a state law that you're following and state regulations. And I just think I'm shocked that you're supportive of a non-uniform way of applying a state law.
They are doing more than
No, it's
what
not
the
more. It's
uniform-
different, Commissioner. It's
No,
different.
it's not different.
Well,
They have to do everything that every other county does.
Except demonstrate there was a discrepancy before they open state ballot, or before they do hand counts. They're not doing everything.
They have agreed in advance to a procedure.
So two commissioners can just decide on their own, I don't care what state law is, I'm gonna do it my way.
No, I'm going to do more than what
No,
the
it's not
state law
more,
requires.
it's different. It's different. You're using the wrong term. It's different.
No, you don't like the fact that it's that what my
No,
term, but
no.
my term is the accurate way to do it.
No, it's not. I disagree.
And I wish you would be so insistent on uniform compliance and enforcement of the statute when it comes to other issues where the county boards deviate from our standards, including New York City's failure to comply with the 30-minute voter waiting time deadline, and
Commissioner, I believe we
there-
told New York City over and over with the full support of this board, they must comply with the 30-minute rule. I do support that. I've always supported that, and I believe I've gone on record with this board insisting that the city board come up with a process to ensure a 30-day or a 30-minute rule at their poll sites. So I don't agree with you at all that I pick and choose. I think you're the ones picking and choosing which one of the laws you want to follow. And we're allowing our counties to do the same, and I think that's unfortunate, and I don't think it's the way we should administer elections in this state. But I can see we disagree, and I don't mean to belabor it. So it's an issue I think is out there. I think it's a legitimate issue, and I'm troubled by it. And I think something should be done. I think if going to the state legislature with an agreed upon statewide practice I'm fine with that, but we need to come up with that then.
yeah, and I'm fine with it too, as long as we
But in the
have
interim,
it.
they should be following state law, not doing it their own way.
But they are all following
No,
state
they're not.
law. What you're objecting
No,
to
they're not.
is they're doing more than what the state
Commissioner
law
Spano and I
requires.
have both stood for election. And I want to tell you, if there was an election where there was 5-vote difference, I'm in favor of what Commissioner Keldon has said. Say, hey, boom, have a recount, full recount, so we'd know who won and who lost.
Fair enough.
With my 30 lawyers sitting around the table.
Fair enough. You would have the right to go to
I
court and
think
have that
probably,
done.
Commissioner, when you were talking, I agreed with you.
Mhm.
When he was talking, I thought, I'm not a lawyer, so I just listen and try to get all the facts. And it seems to me that you're both talking about a uniform system, which we both appreciate. It seems to me that you're looking at the law one way, and he's saying the law is a minimal requirement, not a maximum requirement. And if the people want to go beyond that, that's okay. What's wrong with that? If a person says I have to do 5 things and I do 10, what's wrong with that?
That's not the way the law is written, Commissioner.
Well, that's
It's
the
not a
way he
minimal,
hears it.
it's a standard. It's
That's
the standard.
But that's the way he hears it.
Well, he's hearing it that way because he wants to, but I'm telling you, I'm telling you what the law says, and I think it's unfortunate we're not following the law. I think it's too bad.
We did that over the disclosure of the other issue where Commissioner Kosinski wants to keep secret the cast vote records and ballot images in elections, and where I have said that, and as well as the Committee on Open Government have said that those ballot images and cast vote records are subject to the Freedom of Information Act. And a very conservative Republican judge agreed with our position that transparency is required by the state law and that those ballot images should be subject to FOIL. That case is working its way through the appellate courts now.
The consistency, though, is really an issue. Because, in this term, people are going, I'd say that they're doing more than they should be. But, the minute you deviate from consistency, it allows others to use that deviation for their purposes and as an argument. And I think we should pursue looking at a system that we think would be better.
Fair enough. Okay.
Can we make it?
Board meeting,
Next board meeting, good, yeah.
there was a conflict on the date we had proposed, so I think we have to look at our calendars. The 28th was.
I can't make the 28th.
September
27th work, or?
No, I'd have to do it before that. I'm looking at the week of the 11th.
My birthday again.
It's primary week.
Yeah, so it's 13th, 14th, or 15th.
Not my birthday again.
Is that possible for
Wednesday,
you guys, or is that something you can
14th
do?
is okay
13th,
for me.
13th, 14th?
Birthday.
That's fine.
That's the
14th.
Thursday.
14th is,
What we
well,
have to do?
Is that a bad day?
well, just 13th, I think 14th would be better than 13th. We never know what we're gonna wake up to when there's a
Yeah.
primary day.
Election.
And would the 15th be better than the 14th?
Well, the
Yeah, I can-
14th is my
yeah, for me
birthday,
it
so the
would.
15th would be better.
15th?
It's a Friday.
Okay.
Friday.
That's a Friday.
It's a Friday. And you got the longest drive, so.
Yeah, I don't care. 14th or 15th, either one.
Same,
15th.
14th.
15th is okay.
15?
15th.
I think it's something on
Something to
the
do.
14th of the evening.
Friday the 15th?
Is that okay with you guys?
Yeah, that's fine.
15th.
And could, we need your two signatures, we just
Sure.
have to change that one word, if we can do that
Yep.
on the, or that you can sign the last page and trust Dot and I to change that one word.
Okay,
Either
15th
one.
is the date.
Where do you want it signed?
Last page is for the two of you to sign?
September 15th.
Oh, I'm sorry, did I not give you
No.
versions? Yeah, right there, the last page. Sorry. Each of the three props.
Okay.
Which
one is this?
This is just the.
Oh, you adjourned?
Village official.
All right, so we're, our next meeting, September 15th.
There's no
and,
executive for the.
Motion to adjourn?
I'll move that.
Second.
All right, we stand adjourned.
Okay.